over to Bruce Radke with Vetter Price to moderate the session. Thank you all.
Good morning, everyone. Thank you for coming to the session. The panelists for today's session are Titi Nguyen. She is to my left, the Deputy Attorney General in the Privacy Enforcement and Protection Unit of the California Attorney General's Office. Immediately to Titi's left is Brooks Taney. Brooks is the Vice President of Data Breach Solutions for Epic Solutions. And to Brooks' left is Ryan White. Ryan is a member of the Cyber and Intellectual Property Crime Section at the National Security Division of the United States Attorney's Office here in Los Angeles. And on the phone is Ryan Krieger. Ryan is the Assistant Attorney General in the Vermont Office of the Attorney General's Public Protection Division. So thank you all for participating in the panel. Kind of diving in, we've had a number of these panels on several different net diligence conferences, but we haven't had an opportunity to have someone from the U.S. Attorney's Office. So Ryan, if you could just kind of explain what the office's role is in terms of cybersecurity and data breach response, just to kind of level set.
Sure. So I'm Ryan White, and thank you, Bruce, and Net Diligence and HB Litigation Conferences for inviting me here. Before I say anything of substance, I have to give my disclaimer that I always give, which is any views that I represent are my views only. While I do work for the U.S. Department of Justice, you cannot necessarily ascribe what I say to the DOJ, although I hope it's consistent. It's supposed to be. So I work for the U.S. Attorney's Office, and the U.S. Attorney's Office is basically, for those of you that don't know, essentially the federal DA. We handle the prosecution of federal crimes. I'm in the National Security Division. We also have a criminal division, a civil division, and a tax division. I'm in a section within the National Security Division called the Cyber and IP Crimes section. And there I handle cases involving terrorism and crimes. And within that, I focus on hacks, intellectual property offenses such as trademark and criminal copyright infringement, online threats and exploitation like cyber stalking, and as well as identity theft and credit card trafficking rings. And what the U.S. Attorney's Office does in this context is if there is, I think as pertinent here, a data breach and information is stolen, whether it's personal identifying information, healthcare information, credit cards, law enforcement gets involved. Either I contact the FBI or the Secret Service or Homeland Security Investigations, depending on what the nature of the crime is, and ask to open a case, or they come to me or one of my colleagues. We then issue process to serve subpoenas. We get judges to sign search warrants to accomplish a few objectives. One is to identify the perpetrator or perpetrators in the criminal network. Another is to help mitigate any losses suffered by the victims, and the victim could both be the corporation that is the subject of the attack, as well as the downstream effects on individuals whose information may have been stolen. So we get involved when law enforcement comes to us, so we open an investigation, and we work directly with the victim and other partners to help accomplish those objectives. And ultimately, if the perpetrator is caught and we have developed enough evidence to file a criminal case, we go to the grand jury, seek an indictment, and ultimately, if the defendant either pleads guilty or we take that person to trial and let justice fall where it does.
Great. So TT and Ryan Krieger, I think you guys were on the panel last year here in Santa Monica. Let's do a check. What kind of trends have you seen since we were last together 12 months ago, in terms of kind of things that you've seen, kind of regulatory issues and investigation trends? TT?
Sure. So thank you for inviting me. It's Great to be back, and similar with Ryan, I have to do the disclaimer that the opinions and statements here are my own and do not reflect those of the California Attorney General or the California Attorney General's office. But in terms of the trends we've seen over the last 12 months, I think it's sort of three things that have been related, which is third-party vendors who also to not only service large corporations, but smaller ones, such as the small and mid-sized businesses, who are now also starting to get more vulnerable to breaches, and the focus of breaches are going to be on them because of the move to chip technology.
Okay. Ryan, what about trends that you've been seeing in the last 12 months?
Certainly, we're definitely seeing more issues happening with third-party vendors, and with that, sometimes we get finger pointing going on, who has to give notice, who's responsible for the breach, which from our perspective, we kind of look at that and say, well, so that we can get the notice goes to the consumer, someone has to step up. We're also seeing a lot more creative arguments, I would say, from the tech council, in terms of why it took so long for notice to go out. One of the arguments I've seen coming up a lot is we have a strong belief that a breach happened, but in the absence of clear evidence of exfiltration, we don't think that notice has to go out. That's an argument that our office and I think a lot of the other offices disagree with. So we may start seeing some of these issues which have been kind of discussed and rooted around in the past. They might start getting actually argued and be, finally decided positively in litigation.
Brooks, Ryan just talked about sometimes delay in getting notification out from the time in which the breach is discovered to sending the notice out. Any thoughts on benefits that can be derived from maybe staggered notification in those instances in which you may know some, but not all of the affected individuals?
Yeah, there's really, in my mind, no negatives to doing a staggered type approach. If there's going to be a bottleneck, it always seems to be in regards to the call center. So you can do kind of a two-prong approach. If there's a media release, what that does is it allows call center vendors to understand what the model is going to need to look like as the paper and email notices get out to the consumers. Typically, the call-in rate is much, much smaller when it's a media release. So if the entity is able to let the public know via media, it gives call center vendors much more time to react, ramp, train agents, create models, and then also on very large breaches, the idea of staggered mailings. For example, if it's a 1 million member breach, 250,000 mailings per day for 4 days, it ends up costing the consumer less. It allows the agents to get trained very quickly because they're constantly taking calls, repetition, and it ends up benefiting everybody in the end.
Now, you've kind of talked about the benefits of staggered notification. Is there kind of a numerical cutoff when you think this would be something we should consider?
It really comes down to regulation timeline. We promote it really at any quantity over 250,000, assuming time allows.
Okay. And you talked about the benefits. Are there any kind of corresponding challenges to giving standard or staggered notice, or things we should, at least potholes in the road potentially?
Not really. From a notification call center perspective, there's really no negatives to staggering it. If anything, it allows everyone to be a little bit more prepared from A to B throughout the process.
Great. Any other kind of creative ways, and again, kind of listening to TT's and Ryan's thoughts on timeliness of notification, any other creative things that we could consider in moving that process forward from getting notification out to standing up the call center that you could recommend?
You know, it's typically about a 5-day process getting the data in, where I was running it up against the postal database, deduping, things like that. If things need to happen quicker, there are some corners that can be cut. If the database is fairly up to date, if it's an entity that is sending out monthly invoices, getting those addresses updated within their own organization, you can cut out some of those list work where you're bumping it up against the national change of address, that type of thing. But typically, it's going to be about a 3-day process for the data.
Terrific. So TT and Ryan Krieger, Brooks talked about the benefits of staggered notifications, some of the other kind of creative things to move that process forward. What's your take on staggered notification? I know it was an issue that was discussed, last net diligence, but any further thoughts on that?
We like it. So we definitely do like rolling notification because it does get the information out to the consumers quickly so that they can take action as well. And so the preference is that once you do know of that certain people have been affected by the breach, then you should go ahead and try to notify them. And then add in more people as your investigation continues. So I think I mentioned this last year, and it's still the case. The California office, we did have a settlement in which case the settlement required, going forward, rolling notification, because the circumstances of that case was a lost thumb drive with a spreadsheet of the affected people. And so there, they had the universe, but they wanted to also try to figure out if that was all of the universe. And we felt that 6 months to do that was too much when they had the core of the people known to them at the beginning.
Great. Ryan, any further thoughts on that?
Yeah, I would just reemphasize that we have certainly heard situations where notice goes out way too late, and when we use it as well, we do 90% of the consumers, but not 100 who were waiting, and that is not an excuse that really applies.
And this is especially because, our statutes do allow for notification in terms of putting it on your website, going through the media as well. And so in terms of rolling notification, this is also the mailings and the emails that we would like to have the rolling notification on.
And I know sometimes, we may get a little bit of pushback from insureds and from our clients that maybe they don't know the full story about what happened, or they may not necessarily know all the folks that have been affected, and there may be some hesitancy to providing notices until all those facts are known and the investigation has been completed. TT and Ryan, your thoughts on that?
Ryan, do you want to go first?
Yeah, in terms of, I think that a lot of this is different assessment of risk. I mean, if you think that there's a real chance that it's going to turn out that there was no data breach at all, that's really the only circumstance where I can see delay happening. You don't want, I understand the argument, you don't want to send out notice and then have to say never mind, but I haven't really seen that actually be the situation. A business, I don't think, has to wait until they have an existential certainty of what happened before getting notice out. And usually when we hear that sort of argument, it's because they waited 8, 9 months, and that's way too long. You always have to put yourself in the shoes of the consumer. They just got their data lost. It might be ongoing. They want to know the business acted quickly and got notice out as quickly as possible.
TT and Ryan, stay with you for a bit, but I mean, you've talked about the issue of timeliness of notification. On a positive thing, what are some of the things that our insureds and our clients should be doing, both pre-breach and in response to a breach, that will lessen the chance of getting them on your radar and lessen the chance that a fuller investigation and fines may be assessed?
Let me give you the best phone call I ever received. It happened on Monday. It was from the president of a company that 4 baked goods cafes. He called me to let me know that the previous Thursday they had discovered that there was a data breach. They had already reached out to Secret Service and FBI. They were working closely with them. Notice was going out within the next day, and their meeting set to pull the hard drives from every GLS system. And the president called me personally. Now, this is a local business who's in Vermont. And my reaction to that was, okay, you guys have this covered. Really, I don't have to focus on you at all. So that's one end of the spectrum. The other end of the spectrum is where we have a data breach, and maybe I'm calling them because I've heard from a bank or a Secret Service or something might be going on. And what I'm hearing is, no, we didn't have a data breach. When we're talking about, we shouldn't have to look at this. This is going to be a huge pain in the neck. It's going to be bad for PR. When I hear that story, I immediately start thinking, okay, this is a business that does not want to do the right thing. This is a business that's going to need controlling, and this is where you might end up being an enforcement action.
Yeah.
So really, that first conversation, we have so many breaches that we're dealing with. You know, we decide very early on, you know, what might require focus and what might not. This applies to the 95% of the breaches that are not Target or Home Depot or, you know, showing up in front pages of the New York Times. That's what I'm talking about there.
Yeah. So I agree with Ryan. It's showing full and complete involuntary cooperation and showing us that your focus is on the assessment and remediation of the incident and what's going on and protection of the consumers that are affected, and not necessarily focusing on defending the business practices or looking towards the liability or the exposure. At the end of the day, we are focused on consumer protection, and if you show that that is also a focus and concern, then that would, you know, show us, like Ryan said, that you have your ducks in a row, right? I mean, if a lot of the conference has discussed the steps you should take pre-breach, which is the written information security program, and doing the auditing and making sure that you're complying with that, and then also practicing the drills and the tabletop exercises. And so part of that will show that, yeah, you are trying to assess and remediate and protect.
And oftentimes we tell our clients what we're trying to do is build that narrative, right? So both pre-breach and then post-breach. And I think having an ability to do those steps make our discussions, honestly, with Ryan and TT a whole heck of a lot better than when we don't have that narrative that has been constructed. Ryan White, you know, we've talked about some of the things that organizations who have experienced a breach get on TT and Ryan's radar. On the flip side, for you guys, what could organizations do to help you guys, the FBI and the U.S. Attorney's Office, in your investigation and prosecution of cyber criminals?
So the first thing, which TT touched on, and I think it sounds like it's been discussed at length at this conference, is doing what you can to prevent a data breach from occurring. And simple step of two-factor authentication is a very simple step, but you know, that's a whole nother conversation. Assuming that a data breach does occur, because in the words of the FBI director, there are two types of companies, those that know they've been hacked and those that don't know that they've been hacked. With that in mind, knowing that this will happen, what can you do to assist us? The first thing that you can do is to have somebody designated at your company who is responsible for cybersecurity and data breach response, typically called a Chief Information Security Officer. Also, understanding your network architecture and having a network map. Very important. I can't tell you the number of companies that have a data breach that we go in and they have no idea what information is housed on which server and how the servers are connected to each other. It's very important to maintain logs. One of the things that the FBI or the Secret Service or agency that's investigating this, the first things they'll ask for are, how is your network designed, and give me the logs. We need to look at the logs so we can identify any anomalies to determine where the data breach point was, uncover any malware, and then dissect the malware to figure out if there are any clues to who perpetrated the breach. So there really are two focuses. One is we need to figure out who did it, and then we need to figure out how they did it. And if we can figure out how they did it, we can help close the hole, mitigate losses at the front end. And if we can figure out who did it, then we can go after them, whether they're in the United States or elsewhere, as quickly as possible and use the powers that we have, being the power of search warrants, the power of law enforcement contacts, to hopefully get in and recover the data as soon as possible, hopefully prior to it being disseminated. It obviously depends on what the nature of the data is. We're seeing a lot of hacks to exfiltrate movie content from the entertainment industry. Once that goes out the door, it's usually out the door, because the point of that is to get it as soon as possible and to disseminate it to the viewing public. But if it's trade secrets, the perpetrator may be interested in finding a buyer, and there may be some lead time built in there. And if we can identify who did it, and go get him or her before they're able to find a buyer, we can actually help recover that information and mitigate the harm to the company. So what you can do is be knowledgeable about your own systems, be knowledgeable about where the breach occurred, maintain the logs that enable us to do what we do, which is find people and help you. That's really what can be of most assistance to us. And along the lines of what you've been discussing about, timely notification is key. We understand that companies have a need, often feel, well, the cat's out of the bag. Why am I going to go to law enforcement? It's just going to bring some bad press on us. It's not going to help because the data is already overseas, and let's say it's in a country that may not be so friendly to us. And my response is, you don't know where that data's gone. It may have gone through one of those countries, but very frequently we find that the data is actually sitting in a country that we can get to, or sitting right here in the United States. And timely notification to law enforcement, and of course on the civil side to the Attorney General's office or the other appropriate entity, is critical, because the longer it takes for you to notify us, the more likely it is that there isn't much we can do about it. The more likely it is that your logs will have been overwritten and we can't track it down or figure out exactly what happened. So our preference would be that the moment an entity learns that there's been a breach, that they contact the FBI or the Secret Service or the appropriate entity and continue to take the appropriate steps on your side, but let us take the appropriate steps on our side and work with you to help you and to help the potential downstream victims whose third-party information or personal identifying information was stolen.
All great information. TT and Ryan, in those instances in which criminal activity may be involved in the breach, what, if any, notification to law enforcement and cooperating with law enforcement, how does that factor into your decisions in terms of investigation and fines? How does that play into it?
Sure. So I think the lack of notification to law enforcement to us is sometimes a red flag, because we wonder why you wouldn't want to bring in people to help you with your investigation. There might be reasons, and we'll definitely take that into account, but sometimes getting others to come in to help you show that you are trying to assess and remediate the situation is helpful. And I think what Ryan was saying with, understand your network and have a map and know where things are stored and have logs, we feel that that's part of having a reasonable security, and the lack of not having that information is a red flag for us as well, because there are so many things that it indicates or affects. So for example, not having that information shows us, well, how are you securing your network if you don't know what your network looks like, if you don't know what you're storing, if you don't know who's been affected or what information has been taken. And then because of that, now you're scrambling around to try to find out the full scope of the breach. That delays your notification to the affected customers. Also another red flag for us. And so not having these little things that are the basics that help not only the U.S. Attorney's Office and the FBI and the Secret Service figure out what's going on, it also is a red flag for us on what is going on your end.
Brian, anything else to add on that score?
I would reiterate that I think that not cooperating with law enforcement tends to be a red flag. Cooperating, I don't know to that many points. Although on a related note, that triggers something. One of the arguments, one of the things I hear from lawyers on that about sometimes, and it's usually a lawyer who doesn't have a lot of experience with data breaches, is don't you understand we're the victims here? That sort of mindset, my first reaction is, well, actually, no, your customers are the victims. It's their data that got stolen. They're the ones that are going to suffer the harm. And second is, we're the victims. We all know that getting breached doesn't make you a bad business. We understand that every business gets breached. So we're really trying to communicate more, not really understanding, the baseline understanding of how these things work and, getting any sympathy from us because we got hacked.
Brooks, you've been fortunate enough to stand up a bunch of call centers. I mean, literally thousands of call centers in response to the thousands of breaches. As you're doing that, do you often get questions from affected individuals about status of law enforcement investigation, what's going on? Number one, how frequent is that? And number two, how should we be addressing those questions when those come in?
So as a call center, we typically get FAQs or a script. We don't like to deviate from that script due to liability issues. So that's typically an escalation type process. We work with each entity, develop an escalation distribution list that can be sent out based on the size of the incident, hourly, twice a day, once a day. And depending on, once again, the size, there's a couple different ways that can be sent out. But our call center agents typically don't handle or answer calls regarding regulators, law enforcement, media, anything like that.
And when you say escalation, what is, to the uninitiated, what does that mean?
Yeah, so typically, assuming that the FAQs contain what the call center agents need in order to answer the question, continue the conversation, make the consumer end up in a good spot where they feel like they've been taken care of, they got all the answers they need. That's just a standard call. When there's ever an issue that can't be answered based on the script, the FAQs, that's when it becomes an escalation, and that's what's determined between the call center and the entity, and then how to proceed from there.
Okay. TT and Ryan, we've often talked and heard about kind of reasonable security measures that organizations should undertake or consider to either reduce the probability or the size of the breach. And as a practitioner, right, and as my clients who are trying to get an understanding of what that standard is, could you shed a little light in terms of what your expectations from the regulatory side as it relates to what is reasonable security measures?
Sure. So reasonable means it's also flexible, and it is subject to be changed and updated. And so we are looking for just basic best practices and basic security standards that are known and out there, right? If you talk to any person who's in security, they'll tell you, what the basics are. And so we're not looking for the 100% bulletproof, top-of-the-line security, because we realize that it doesn't exist. But we are looking for something that is reasonable based on what's known out there and based on what information you have to protect.
Great. Ryan, any further thoughts?
Sure. I can understand why businesses might be frustrated by the lack of guidance and regulation, especially if they could expose the business to liability for not having that level of appropriate security. variation of business. What I do tell businesses is that if you think about it from an enforcement perspective, if we have to actually bring an enforcement action, if we have to actually sue a business, we don't want to bring the action where there is a battle of experts over what the appropriate encryption technology was. We want to bring the enforcement action against a business that has such bad security that even a layperson could recognize that the security is really bad. And there are plenty of those businesses out there. So that's really, I mean, it's kind of like, you don't have to outrun the bear, you have to outrun the guy next to you.
And TT, you've mentioned this before about some settlement agreements that your office has entered into entities, and Ryan, I know that your office is as well. What role do those settlement agreements play in terms of kind of educating us to kind of get an understanding of what reasonable security measures are expected? Can you talk about that?
Yeah, I think they're useful as well because we are hoping that with each settlement, people will see what we're expecting and what level improvements that we would like to see out in the world and in the industry and in security. So, for example, I don't think we have anything where we've said you need, a certain level or a certain product of security. So for right now, we've been focusing on things such as a change in the corporate structure and a change in the organizational thinking. So we recently had a settlement where we have required the company to have someone who is responsible for compliance of privacy laws. And that person will report to the chief executive officer or other executives about concerns that they have with the corporation's compliance. And so that is to start getting companies thinking that this is an issue that that should be important to the corporation, and it should be important to high levels within the corporation.
Great. Ryan, any further thoughts on that regard?
Yeah, I think that, any enforcement action we bring, we try to internally boil it down to, the techniques of the value. We do try to communicate that. We had a settlement with a bank that lost some backup banks. And that was the process, and they took too long to get notice out of that. So that, the message of that settlement is you have to, take more caution about what happens to your backup banks, and we'll, do something with that. We had a settlement against a small business that had notice of breach and didn't take steps to actually remedy the breach for several months. So the message of that was, if you get notice of a breach, then you better fix it as soon as possible. I think enforcement actions and settlements are a major way to communicate to business that we're paying attention to these things and do fail to take these, basic steps that anyone would expect you to take. That's what's going to generate enforcement action.
Great. All great information. So we've got about 10 or 15 minutes left. We've got a couple questions, but before we kind of wrap up, here's your opportunity to give our fine panelists some questions. So if you could, given that Ryan's on the phone, if you could step up to the mic and ask the questions, that would be great. Any questions from the audience? So, yes, sir.
Yes, what legal theories is the U.S. government pursuing in this area? I'm very familiar with what the state laws are here, particularly in California, but what statutes is the U.S. Attorney's Office using typically in data breach situations?
So our primary targets are those who are perpetrating the breaches, not the companies that have suffered a breach, which might be different from what TT and Ryan are talking about, because we have criminal standards that are higher to meet in terms of intent requirements, the proof beyond a reasonable doubt, things like that. So we're usually going after the targets are usually those who are actually perpetrating these attacks. We have a number of statutes that we can use. The one that I use most often is Title 18 United States Code Section 1030. Title 18 is the criminal code, most of the criminal code. 1030 is essentially the hacking statute, unauthorized access to do a variety of things, whether it's to just obtain information, to commit fraud, to commit some sort of destruction, as in implanting a virus, to destroy systems. So that's a statute that we use a lot. If it's an intellectual property case, we can use 18 U.S.C. Section 1832, which is the theft of trade secret statute, civilly, or for private entities, or 1831, which is theft of trade secrets to aid a foreign government. We can use 17 U.S.C. 506, which the penalty provisions are in Title 18. That is criminal copyright infringement. It basically takes the civil action for copyright infringement and criminalizes it by adding heightened intent requirements. We have 18 U.S.C. 2320, which is criminal trademark infringement. Of course, there are the pure identity theft statutes, 18 U.S.C. 1028 and 1028 Big A, which is the aggravated identity theft statute, and Section 1029, which is the essentially access device fraud, credit card trafficking, more or less, and similar type devices. And we can often use, it's a tool that's fairly broad, that's very helpful, is the wire fraud statute. As long as you can show that there was a material misrepresentation and that there was a wire that affected interstate commerce, we often can charge them as wire fraud. So we have a wide array of statutes that we can charge. We obviously don't charge them all in every case, and there are often many statutes that can be charged in a given case, and we just have to pick and choose depending on how we want to craft the indictment and what we think we're most likely to prove.
I think there was another question.
I had a follow-up question for Ryan White. When a company is a victim of a crime, and you're working in that kind of relationship, do you make referrals to the substantive federal regulators like SEC or FTC, where there may be more of an adversarial relationship? Could you give us a sense of the dynamic of that, or whether you take the initiative to do that, or whether they contact you and so forth? Because the relationship can change over time.
I understand that, and I can tell you that I personally have not. This is an emerging area, and the federal regulations are evolving, so I can't make any promises as to how that will evolve. I personally have not done that. I don't know whether other AUSAs have done that. I recognize that there is a concern, I think, that I hear frequently, private entities saying, we don't want to work with the government because we understand, like, the cat's out of the bag, and once we give you information, if you file an indictment, that information is going to become public, and it's going to, give us bad press and all that. Why should we even do this? And my response is, I agree with Ryan Krieger that the people whose data is stolen, the third party, the victim, are victims. We also view the company that has been hacked as a victim, and we work with you directly, and we respect your privacy to the best that we can. For example, perfect example is I just finished a trial last week in a theft of trade secrets case where the defendant had worked for the company, stole a lot of their proprietary information, and sent it out to their competitors around the world. We had to turn over those trade secrets to the defendant, but before doing so, we got a protective order from the court that ensured that that trade secret information would not be shared at all, and indeed at the trial, the trade secret information was not displayed publicly, so to protect the victim's rights. So we are always looking for ways to protect your rights, to do our best to contain the information. We don't just turn things over or make things public willy-nilly. We provide advance notice. So you should not be afraid to work with us. As to the initial question, I don't really have a good response for it, other to say I haven't done that so far. It certainly is a potential risk, that could be emerging.
And any other follow-up questions? So my guess is we'll probably have a similar panel next time we adjourn 12 months hence. So if we could all kind of look into our crystal balls and kind of go down the list and maybe give your thoughts on what we're going to be talking about in the next 12 months and what we're going to talk about the next time we reconvene. TT?
So I think two things. One is breaches with small and mid-sized businesses as the attackers try to squeeze out the last of they can out of the magnetic stripe payment card information. And then I think also a focus on breaches of medical and healthcare entities.
Great. Brooks?
I keep hearing about different ways to monitor the consumer's data, whether it be health monitoring, different types of monitoring arenas being brought up rather than just the traditional credit monitoring. So I suspect that over the next 12 to 24 months, there'll be some changes there.
I think that the intrusions have somewhat evolved very rapidly from intrusions to steal data that is readily usable, obviously usable, like credit card information. It moved on to the Anthem hack and stealing healthcare information that can be used in ancillary ways, like stealing that information, then filing a fraudulent tax return with it. That can have serious consequences for individuals. And then we saw something like Sony happen, which my section is working on. I'm not working on it, so I only know what's public, but appears to have been this odd mix of sort of not revenge, but some sort of like malice-based attack just to harm the company by revealing embarrassing emails and the like, and also to steal information. So these hacks are evolving and can come for any number of reasons, which just highlights the need to realize we are all vulnerable. We all have information. Even if you have information that you think nobody would want, there may be a reason for somebody to intrude in your system, and so everybody needs to remain vigilant.
And Ryan?
I think we're going to be seeing more enforcement actions involving third-party data processors. Like I said before, businesses that flout their obligations to report data breaches entirely. And I think for a while the regulatory environment is trying to get numbers around big data and kind of bigger picture privacy issues. And I suspect that we're going to start seeing more around that and possibly breaches involving that kind of thing.
Well, I to wrap up our session, I want to thank you all for attending our session, and want to especially thank TT, Brooks, Ryan, and Ryan. It's been a real honor to participate on the panel with you, and greatly appreciate all your insights and your assistance on this. And obviously, we'll be here for a while if you've got any follow-up questions. So thank you very much.
Great, thanks.